Secretary of State for the Cabinet Office, I believe the first Secretary of State, to this session on devolution and exiting the EU, and this will be our concluding evidence session. So the purpose of this is not to rehash a whole lot of things that have been said before, but to get on record some of the pertinent issues which we feel where we have gaps in our evidence in terms of the government's view. If I can start by talking about the introduction of the EU Withdrawal Bill, which was rather peremptorily published with very little consultation with the devolved parliaments and devolved administrations. And was drafted in a form in Clause 11 that was regarded as what has been described as constitutionally insensitive. What lessons do you draw from the reaction to all this that this has provoked, and for the future, rather than just accusing the government of being antagonised towards the devolved parliaments and devolved administrations? What do you perhaps, looking back, think we could have done better as a United Kingdom Parliament and government, and that we should learn from this?
I think that, in one sense, Chairman, I think I should actually start to say I'm assisted by Lucy Smith, who heads up the
I beg your pardon, I didn't do the usual introduction.
Affairs Division of the Cabinet Office. You're putting me, Chairman, in a slightly difficult position because, of course, those decisions about the introduction of the bill took place when I was not in my present post. I think if I reflect on that, I think that the difficulty arose in part because of the need for urgency in respect to the withdrawal bill, given the 2-year deadline under Article 50 of the European treaties. That in turn meant that the bill had to be introduced in sufficient time for it to get through all its parliamentary stages and for consequent secondary legislation then to be taken through in order for us to have a coherent statute book at the end of March 2019. So that, I think, explains the urgency with which that bill was taken. And that, I think, did necessitate greater speed, probably less time for reflection and consultation than one would normally expect to be the case, where in cases where there was not that kind of deadline. Looking back, I think that a lesson I would draw is that of the need for intense and frequent consultation, after a bill is published, and obviously ideally one would want to know beforehand what the question was. I think that if we look back at the record, I think that there was at the start a big difference of principle that asserted by the governments of Scotland and Wales that the bill should not go ahead, that none of the powers that were proposed to exercise under the bill that touched on devolved competences should go ahead without consent having taken place, which in my view and my predecessors' view went beyond the Sewell Convention. But actually, with very intensive work by civil servants on all sides and by ministers, particularly I think in the last few months, we've managed, I think, to get the bill to a place which fairly respects the interests of all parties. As you know, Chairman, we completely reversed the presumption that was in the original Clause 11 of the bill. So now, instead of all powers staying at Westminster until they are transferred to devolved level, the statutory presumption is that powers go straight to devolved level unless secondary legislation is introduced under the power in the bill to hold them at Westminster. And we adjusted the provisions of the bill in many respects, in order to take into account the views that were expressed by the Scottish and Welsh governments, by the relevant parliamentary committees. So not just on that principle, but on the issue of the sunset clause, on the question of giving statutory protection against amendment to the Government of Wales and Government of Scotland Acts in line with what the bill had already provided for in respect to the Northern Ireland Act. So there's a number of ways I can point to, I think, in which we did make very good progress. And I would actually like to put on record my thanks to not just my own officials, but also to the officials of the devolved governments, who I think were making contact pretty much daily during the last few months of talks on this. And in all my dealings with Mark Drakeford and Mike Russell, despite differences of opinion that we have had, and particularly in the case of the Scottish Government continue to have, I think that both, I felt, always approached our discussions in a constructive fashion.
Why do you think it took so long for the government to bring forward any amendments?
Because what the government was seeking to do was to only bring forward amendments when those had been agreed with both the Scottish and Welsh administrations. We had hoped that we would be able to do that before the bill left the House of Commons. And indeed, the Secretary of State for Scotland, when he made the original commitment at the dispatch box to bring forward changes to what was then Clause 11 of the bill, did say that he hoped to bring forward agreed changes. And we were not able to get agreement before the bill left the Commons. We then, having discussed things further in great detail with both devolved administrations, looked at the representations from parliamentarians, and having also sounded out views in the House of Lords, we then tabled amendments, as you know, Chairman, in the House of Lords, but without pushing them to a division at that point, so that we could reflect further between committee and report stage in the House of Lords, and then bring forward measures which by then did have the support of the Welsh Government as well.
And of course the SNP are not represented in the House of Lords by their own choice, but nevertheless they're not. So their opportunity to debate these amendments was very limited in the exchanges between the Lords and Commons right at the end of the legislative process. And of course we found that because of other circumstances it was only confined to 20 minutes. I don't begin to defend the histrionics that followed, but what lessons does this send to us about how we should handle these very contentious matters like this when they arise in future?
I think, one hopes that they won't arise in that fashion again. I mean, I don't think that anybody, certainly not I, was happy with how little time we found ourselves with for that second group of amendments at Commons consideration last week. I mean, one can debate whether time was spent unnecessarily on particular amendments that might have been grouped because they in effect were saying the same thing. I think I can point to the fact that considerably more time was allocated to the withdrawal bill than had been allocated in the Scottish Parliament to the continuity bill that they took through. That we did allow a full 12 hours of protected time, not just time, but a protected time in the Commons for consideration of Lord's amendments last week. But nevertheless, I mean, I would certainly hope that we can seek to avoid those
if we were to recommend
those circumstances again,
that on any future occasion, the devolved parliaments, matters affecting the devolved parliaments, should get their own protected time in a United Kingdom Parliament timetable motion, because otherwise, England being so gargantuan in size compared to the other parts of the United Kingdom, how are they not to feel slighted?
I'd be interested to see if the committee came to such a recommendation. I think obviously I and colleagues in Cabinet will want to reflect on the implications of that for the handling of business, because we have a lot of business that does touch upon devolved matters, and most of it is relatively uncontroversial because most of it has actually been sorted out and agreed, and LCMs have been passed in the preceding weeks.
Marcus Fysh.
Yeah, this side of the committee, Chair. Just to go on from what the Chair was saying about the way in which relations with the devolved administrations is managed in the future. I mean, would you be able to say how constructively you think they have acted and operated through this process?
I think through the process of the negotiations, the conversations were constructive. I mean, very clearly, the Scottish Government in particular, because it's made up of a party that is committed to separation from the United Kingdom, has a particular constitutional priority, whereas the Welsh Government is in a different position. But certainly, I mean, Lucy may want to say something about the official level contacts, but the official level contacts have been constructive, workmanlike, professional all the way through, and continue to be. You know, there have been discussions continuing this week on various devolved matters that require civil servants in Westminster to talk to civil servants in Edinburgh and Cardiff. At political level, I mean, I know both Mr. Russell and Mr. Drake for different political parties from myself, but again, I think it's been a professional relationship. And I think that I have always tried to make myself available when either of them has wanted to talk to me. There have been 3 formal meetings of JMCEN so far this year. I hope that we will have another one in the very near future. I've offered one for this Friday in the margins of the British-Irish Council, because that would enable us to meet formally ahead of the June European Council. And in addition to that, there has been a joint ministerial committee chaired by the Prime Minister, with the First Ministers attending. And there was the critical meeting in April when we went through the details of the proposed compromise package, which was not a formal JMCEN, but where Mr. Drake, Mr. Russell and I went line by line through the text of what we were proposing, and we took on board drafting amendments that both of them suggested. So I think they have handled it professionally, and I was very disappointed that when Mike Russell called me to say that the Scottish Government, having considered in Cabinet, was not able to accept what was on the table. All 3 of us left that meeting in April, agreeing to take the proposals and present them to our respective cabinets, because they did need collective agreement from all 3 administrations. And I was very pleased the Welsh felt able to come on board, disappointed the Scots didn't. But I think that the conversations I've had with Scottish ministers, Lucy's had with officials, have been professional throughout. I mean, do you want to say anything about the officials?
So the political contact through the JMC meetings and the bilaterals that the Minister has is all underpinned by a really significant programme of work now at official level. So the big policy question, I suppose, which sits underneath the bill is about UK common frameworks, and that has been a really significant programme of work between us and the devolved administrations over a number of months. I think we've done 28 different deep dives with them on a whole series of subject areas over the past 6 months, and we're into a phase 2 of those deep dives now. We know that we need to collaborate together on the statute book and on the secondary legislative programme, and we're set up to do that, and indeed on sort of making sure the devolved administrations have sessions and are properly briefed in order to participate in discussions on sort of phase 2 of negotiations is another sort of programme that we've got.
So are there things that we are doing or looking to do in the future to sort of build on this process and foster a constructive atmosphere going into the future? Clearly we've had to talk in this context about some of these things. I think it would be nice if we managed to make some of these features of our cooperation more of a permanent thing, perhaps at that level of depth. than has happened in the past, should it be required.
I think that's right. I think the deep dives in particular have given us a really good model, in fact, that we can deploy in other areas. And also over the past sort of 12 to 24 months, in fact, what's happened across Whitehall is a deepening of relationships between the devolved administrations of various departments as well. So there are some processes that we run centrally, like the work on UK frameworks, but also there's a big read across the departments working individually with the devolved administrations. So DEFRA, for example, is sort of engaged with their counterparts on an area of joint interest. So I think there are definitely lessons to be learned, and that we are learning in working out what are the successful models that allow collaboration even on something which we might not immediately sort of agree all of our priorities on.
I think it's a process of cultural change. And it is a matter, in my mind, of just trying to develop and strengthen the habit of working together and consulting, acknowledging that there will sometimes be political differences, particularly when different administrations are run by different political parties.
Now, the division bell has gone. I suggest we adjourn until, in principle, soon after 4 o'clock, unless we learn that there is definitely going to be a third division. Okay?
Thank you.
Thank you.
The proceeding is currently suspended.
Our predecessor committee produced a report called The Future of the Union, and it talked about the atmosphere of trust and goodwill that we've been speaking about being important to be developed. And I just wondered if you could say how important do you think that is? How have we as a government responded to that report?
Well, I think since the December 2016, I think that the previous committee made its report, and I think since then there have been some significant steps to take things forward, and I mean we've obviously established the JMCEN to provide a formal mechanism to enable discussions to take place between ministers about withdrawal from the EU. And as Lucy referred to earlier, we've also now set up a new ministerial forum, which my colleagues Chloe Smith and Robin Walker co-chair, which meets in different parts of the United Kingdom in order to engage the devolved administrations on some of the detail about if you like, phase 2 of those negotiations on the future preparation for the future relationship that we want to negotiate with the EU 27. And that work clearly has to involve departments right across Whitehall. This cannot be just micromanaged from the Cabinet Office or from DEXU. So that has been taking place. I mean, JMCEN has now met 9 times. I have chaired 3 of those meetings since January, and as I said, I hope that we will have a further meeting on Friday this week. In addition to that, there are bilateral meetings of various kinds. I mean, my first calls after being appointed to my current office were to the First Minister of Wales and the Deputy First Minister of Scotland. I have been to all 3 devolved areas of the United Kingdom. To Scotland, I think, more than once since my appointment. And I think that in less formal communication, exchanges of letters, phone calls, are part of trying to build up that atmosphere of trust.
Yeah, because in your response, I think you mentioned the importance of acting in good faith and in a constructive manner, and obviously things have been said by some in the political discourse around it that have questioned whether good faith has been used. I just wondered if you had any particular evidence, apart from what you've just mentioned, of the good faith aspect of government.
I think I would argue very strongly, as far as the United Kingdom government is concerned, that we have acted in good faith. We have said from the start that we wanted to seek and secure consent from the devolved administration, both Scotland and Wales, in the absence of Northern Ireland Executive, to the EU withdrawal bill, since it does, in the course of it, do intersect with devolved competence. We have followed that up by making radical changes to the bill. We have supplemented the bill with an intergovernmental agreement which was discussed in detail with both Welsh and Scottish officials and ministers, which reflects comments and amendments that both those governments made to us, which in the final resort the Scottish Government felt that they did not want to accept this. But, for example, that intergovernmental agreement, by political commitment, binds the United Kingdom government to continue to apply the Sewell Convention to any new legislation brought forward, either under the aegis of the withdrawal bill or to further pieces of legislation. So, to take two topical examples, we are expecting to need to introduce both an agriculture bill and a fisheries bill to provide for there to be regulatory regimes after we leave the European Union. Both of those will be subject to the Sewell Convention. We will seek consent from the devolved administrations in the normal way. What I have been unable to accept is that there should be a right of veto for one of the devolved governments or parliaments over a United Kingdom-wide framework, or that the Sewell Convention should be interpreted as meaning something that it does not, as Lord Sewell himself pointed out earlier this week. The convention named after him is just that, is a convention. If one goes back and looks at the text of the Scotland Act in 1998, the reference to seeking consent is preceded by a sentence saying that nothing in the Act shall affect the power of the United Kingdom Parliament to legislate for the United Kingdom.
Yeah. So when it was said by Michael Russell that a very substantial lack of trust on both sides had emerged, which is evidence that he gave to us when we visited Scotland recently, what is your assessment of the current level? You mentioned earlier the fact that your negotiations with Mr. Russell had resulted perhaps in what you thought might have been an agreement that might be acceptable. So did the First Minister in Scotland overrule that?
Well, I think that's not a question I can easily answer. The First Minister has made public statements in Holyrood to say that she regarded insistence on consent, not merely seeking consent, as a red line for her. But as I said earlier, Mr. Russell, in all his dealings with me, has been completely professional, and when the meeting finished on I think it was the 16th of April this year, 16th or 17th of April this year, all three ministers, myself, Mr. Russell, Mr. Drakeford, accepted that the texts we had been talking about would have to go back to our respective cabinets. Now, what I cannot do is know what went on inside the Scottish Cabinet discussion.
Thank you.
Cheryl Gillan.
Can I first of all ask Miss Smith, Lucy Smith, Mrs. Smith, I don't know quite. Lucy, fine. You mentioned the 22 areas where you've done the deep dives. It would be really helpful if we could see exactly what those 22 areas, and I wondered if you could just drop a note to the committee so we can actually see the 22 areas where you did the deep dive.
Yes, of course, we can easily do that.
Yes,
so
I don't want you to
we've
list
published
them,
a long list of the different areas, but we can certainly
That would be
write.
great. And then, Minister, you've not mentioned yet the Secretaries of State for Scotland and Wales. Are you replacing them in your job?
No, there is
How do they come?
very honest answer, and I'd be in serious trouble.
And how do they come into the equation?
If I said anything different. No, they remain. The three territorial secretaries of state remain very important voices for Scotland, Wales, and Northern Ireland at the cabinet table, and I try to meet weekly with all three of the territorial secretaries of state. So we've had the opportunity to touch base on what's going on and to coordinate what we do. And I would say not just in terms of our dealings with the devolved governments, but in terms of what we need to alert our cabinet colleagues to about the particular interests of Wales, Scotland, and Northern Ireland. Because while I think Whitehall is getting better at taking note of devolved concerns, sometimes it is, something can not be spotted that needs to be spotted.
But why are we reinventing the wheel? And you perhaps know exactly what I'm talking about, and certainly Mr. Jones knows what I'm talking about. Back in 2010, I proposed, and it was accepted, a cabinet subcommittee with a minister being sent from every department of state, specifically with the responsibility of looking at their department and how it interacted with the three devolved administrations. So you had a cabinet subcommittee that was meeting, so you were coordinating across departments, and you were coordinating with the secretaries of state and with the cabinet office. Now, the Liberal Democrats were in a coalition with us at that stage and actually put a veto on it and blocked it after 3 meetings. But we appear to be reinventing something which is pretty similar, but not quite there yet, because that is how you most efficiently coordinate, both with the devolved administrations and across government, because it is a three-dimensional picture where we all need to be singing, not necessarily from the same hymn sheet, but with the same knowledge of what is on the hymn sheet.
Well, obviously it's not a decision for me, as the committee would appreciate, as to what cabinet committees and subcommittees are established. But I think that what we're trying to do is to ensure that we don't simply rely on a single cabinet committee to deal with all devolved issues, because I think there is so much business that is having to be dealt with that we're trying to be a bit more nimble in dealing bilaterally with the Environment Secretary on Fisheries, Agriculture and Environment, with the Industry Secretary on Industrial and Energy topics, and so on. And I think the weekly meeting that I have with the territorial offices enables us to ensure that is being managed. And of course, it remains the case that every Secretary of State, when they wish to bring forward a new policy by way of a right round, is expected to spell out what analysis they've made about whether this touches on devolved competences, if so, how, and what the devolved interests and opinions might be, and to show that they have consulted with the devolved. The territorial ministers and I are also members of the Parliamentary Business and Legislation Committee, chaired by the Leader of the House. So there is the opportunity there, when that committee considers whether to grant approval for legislation to be introduced, to double-check whether all the necessary political horizon scanning, as well as formal official consultation, has taken place with the devolved.
Can I just take a bit further down as well? Do you think that there would be some sense of having a forum where you could have the Assembly members and members of Parliament together, and members of the Scottish Parliament and members of Parliament together as well?
I can certainly see the advantage of that. I mean, I think what I would say is probably it's not something for the government. It's not something for the government to set up. That would be something that this House, or this House with the House of Lords, might wish to approach the Scottish, Welsh, and due course Northern Ireland legislatures about. There are obviously logistical challenges, but I think that is a matter for Parliament rather than for government.
Thank you very much.
Thank you. That's question 9 disposed of. Mr. Jones, question 4.
Yes, could I just come back to the point you made in one of your answers? You said words to the effect that there could be no question of the Welsh and Scottish administrations vetoing the bill. Just so I can be clear on this, was there a suggestion at some stage that they had a power of veto?
argument from the Scottish government in particular. The reason I hesitate, Chairman, is because I feel it is for them to make their case rather than for me to summarise it. But their case has been that it would be constitutionally improper and a breach of the Sewell Convention for us to take the withdrawal bill through all its stages and to royal assent and to implement it without a legislative consent motion being passed.
Yes, it might amount to a breach of the Sewell Convention, but as you rightly said, that is simply a convention. It would not be thought to give rise to a veto. Am I to understand that veto was your word rather than a word that was used by anybody else?
Veto is certainly my word, but the argument that was put to me repeatedly, and I think was repeated in the exchanges in the Chamber both last week in points of order and this week in the Standing Order 24 debate, was that the convention required the United Kingdom government to not to take forward and complete proceedings on the bill without an LCM having been passed.
Yes, but that being simply a convention and nothing.
Well, that is and always has been my argument.
Yes,
and I believe that is borne out both by the words of the 1998 statutes, by practice ever since, and by the Gina Miller case in the court, and by what Lord Sewell said the other day. But I think the language used by the Scottish government seems to me to imply a wish on their part to make the requirement for legislative consent binding, and which is and the why I think the only, since the Scottish Cabinet took its regrettable decision, they have not come forward with further suggested amendments, save that we should write into law, into the statute, a requirement for consent to be granted before we could introduce a freezing power with the UK framework, or alternatively to drop the order-making power altogether from the bill.
Which I take it you're not disposed to do.
Which I've said, I've said repeatedly on every occasion that we are not prepared to do. It would be in my view, that would be a pretty fundamental rewriting of the 1998 devolution settlement.
Yes, and devolution has, of course, now been an established feature of the constitution of this country for around 20 years. It's interesting that the debates that we've been having over the withdrawal bill do tend to indicate that there is no settled agreement as to what devolution means. What would you say it means to the government when one says that a matter is devolved?
It means that powers have been conferred by this Parliament upon a democratically elected body and an executive in part of the kingdom, together with either complete or a fair degree of autonomy in how those powers should be exercised.
And of course, in this particular case, for example, agriculture is a devolved competence.
Yes,
for both Scotland and Wales, and also for Northern Ireland. Nevertheless, it's proposed that the withdrawal bill will, in practical terms, interfere with the devolution settlement to the extent that certain competences will be retained, albeit temporarily, at Westminster. So that, it seems to me, is a slight gloss on the meaning of a devolved competence.
Well, I think there are a number of things to say in response to that. I mean, the first is that, as Mr. Russell himself has said, and Lord Sewell repeated this week, we are not in normal times. The withdrawal of the United Kingdom from the European Union, I think, does create a quite exceptional circumstance. Secondly, when the allocation of powers was debated and embodied in law in 1998, 97, 98, the assumption by everybody was that there were certain things where authority would be exercised at European level. And we have, throughout the years in which devolution has existed in this country, operated under a UK-wide single market, which derived from European level rules. We have relied in terms of the negotiation, enactment and implementation of international trade treaties on the European Commission's exclusive competence for external trade. Now, with those competences leaving European level, then it seems to me it is right to have a way in which to calmly to work out which power goes where. There is only a very small number of those competencies which do intersect with devolved competence, but which also involve something that is of critical importance right across the United Kingdom as a whole. And the message that we've had in particular from business in Scotland, Wales, Northern Ireland and in England has been that they want to ensure that the benefits of the United Kingdom-wide single market, common market, whatever we call it, are retained after we have left the European Union. It would be a significant additional cost to business that would be borne in terms of jobs or in terms of higher prices were, for example, a salmon processor in Scotland to have to face different requirements for food labelling depending on whether the product was sold in a supermarket in Scotland or a supermarket in England. If a customer in Aberdeen wants to buy paint produced elsewhere in the United Kingdom, then clearly it makes sense for the same chemicals regulations to apply to the shop in Aberdeen as to the producer in Cardiff. So it is in everybody's interest that those are maintained. And all we are saying is that the current regime, as it exists at Brussels level and with which the devolved administrations of the UK government have all lived for some years now, may continue for a time-limited period while we sit down together as devolved and UK governments to work out what the right UK-wide framework should be for the future.
And as a matter of clarity, am I right in thinking that for practical purposes the devolved administrations and assemblies will not be exercising any fewer competences than they did prior to the withdrawal from the European Union?
No competence that they currently exercise is being removed. More than that, about 80 new competences under the way we have now constructed Clause 15 of the bill will transfer immediately when we exit the EU from Brussels to devolved level.
Chair, if I just may ask a supplementary on that. Having a single market for the UK, I basically support the Union and so on. But the European Union is very strict about what it allows member states to do. And if, for example, you take your case of paints and chemicals, yes, it might just be that one or two of the devolved administrations, devolved legislatures want to have stricter rules about what chemicals can go into what than would this now pertain within the United Kingdom. And one can see those who support the market might say, no, that's not allowed anymore. Could you not see conflicts arising? There's one specific issue, for example, minimum price of alcohol, where there might be some significant differences too.
But I mean, minimum price of alcohol, I mean, has been ruled as you know, within competence already, and despite a challenge based upon European law in the last couple of years. I think, I mean, Clearly, there is Mr. Hopkins is right, there is a risk of that, but I would weigh against that to other things. First of all, we need time to sit, which is what the freezing power is designed to provide, to ensure that we don't have some sudden divergence of regulations within the United Kingdom when we leave the EU, but that we can sit down calmly and work out what the best regime is, including whether that UK-wide framework should allow for a margin of appreciation in terms of divergence. But the other point I'd make is that under WTO rules, the United Kingdom, in seeking trade agreements with other countries or on non-trade matters, so sitting down to negotiate an international treaty with another country, will need to be able to show that it can implement that treaty or trade agreement across all of its territory. I mean, that's a normal requirement of international relations. International relations, of course, are a reserved matter in any case, but that is why the international need to implement our international obligations is one of the specified criteria for a UK-wide framework. And perhaps I could just add this, because Mr. Hopkins' point is very pertinent to this, that those criteria, preserving the UK-wide common market, enabling us to implement our international obligations, enabling us to negotiate, enact and implement new trade agreements and treaties, making possible the stewardship of common resources, ensuring the security of people throughout the United Kingdom. These were criteria that were agreed collectively between the UK and the devolved governments at a JMCEN meeting in October last year. Before my time in this office, but the governments of Scotland and Wales accepted the significance of those principles and for the need for there to be UK-wide frameworks that took those into account.
Thank you. Mr. Fysh.
So just to clarify, so what you're saying, if I'm right, is that in those particular areas where that agreement in October happened, in effect, the UK will permanently retain the competence and the powers, for example, in agriculture, to have a common framework which we can say to our WTO interlocutors that we can deliver. And so is that correct? And then if so, how will the government then involve the devolved administrations in discussions, for example, with regards to future free trade agreements that we might do that may or may not make changes of one kind or another to what our commitments are in those areas? How will we ensure devolved administrations are involved in the process?
In terms of the second half of Mr. Fysh's question, the Department of International Trade, in the particular example of sites, has a responsibility to take devolved interests into account. Now, this happens when we seek to negotiate free trade agreements. It happens in the EU context. I mean, having been Europe Minister in the past, I know that when it came to CETA, for example, when it came to the EU's negotiations with Korea over an FTA, such interests as Scotch whisky were taken into account. And on the other side, in terms of defensive interests of the UK, the interests of Welsh land producers were part of the package of considerations that UK ministers and officials in leading those negotiations or talking to the Commission in those respects were bearing in mind. On the broader point, now our intention, first of all, while the original clause 11 of the bill imposed no sunset clause, the new clause 15 imposes strict sunset clauses. The power to make regulations to freeze current arrangements only continues for 2 years after royal assent. It is a power to freeze new regulations. It is not a power to diverge from current the EU regimes. It is a matter of continuing the existing rules. Secondly, any regulation made under the freezing power can last no longer than 5 years, and we have said publicly that our intention would be to negotiate agreed UK-wide frameworks and either introduce those on a legislative or non-legislative basis as appropriate, as far in advance of that 5-year deadline as we could. We also say in the intergovernmental agreement expressly that we will be seeking consent. We'll be applying the Sewell conventions to all our proposals on future frameworks. So the answer is I would want a UK-wide future framework that is permanent, but with some sort of review and amendment mechanism to run into the future after any temporary freezing power has dropped away. But my objective is to seek consent and consensus with the devolved on this. They have significant interests. It's right we should be working hard to take those into account and reflect them in the UK-wide framework. It's in all our interest to get this right.
Is it worth saying a little bit on where we are on the
Yes.
24 areas? So we've got 24 areas listed where we think we may want to explore legislative frameworks in the future. So if we want to introduce those legislative frameworks longer term, that will be future primary legislation. But there's a lot more work to do through this programme of deep dives that I described to come to a conclusion with the devolved administrations about what the nature of those legislative frameworks should be, what they mean in competence terms. I don't think we've taken any decisions on sort of how that's legislated for, and we've also not yet determined precisely what we legislate for in each of those 24 areas. It doesn't mean that we'll have one single regulatory framework necessarily covering the whole of each of the 24 areas. We might think that there needs to be a minimum standards regime, for example. We might think that there are some very specific issues to do with the WTO that need protecting. So all of that requires detailed further work over the coming months before we can reach conclusions.
So how much work have you done so far on thinking about the impact that it will have on future free trade negotiations that the Department of International Trade might undertake if there is the operation of the Sewell Convention, which may in certain circumstances constitute a veto for certain parts of the UK population?
So, I mean, that question is factored into the work that we're doing on UK-wide frameworks. So, obviously, as the Minister set out, the ability to conduct international trade was one of the principles agreed by the JMCEN in October. That informs the analysis that we're doing jointly with the devolved administrations, and the Department for International Trade is engaged in that work within Whitehall. So these are different interests that need to be balanced with each other as we work out what the future framework should look like.
Okay.
Yes.
Thank you very much. One of the ostensible benefits of devolution when it was first mooted was that it would enable difference to emerge between the various parts of the country and that there would be divergence. How do you propose to ensure that the principle of divergence should be maintained, given the fact that it's going to be necessary for these frameworks to be put in place?
Well, the frameworks that we're proposing and the criteria we're proposing are limited in scope. They are significant areas, but which have a clear UK-wide application. And I think if you look at what's actually happened in practice, that if I look at how Scotland has, with its separate legal system, decided that it's going to try a different approach from England, for example, in introducing a presumption against short-term custodial sentences, in acting ahead of the rest of the United Kingdom over upskirting. I mean, there are various clear areas where there has been a difference, and I honestly don't see that as something that is under challenge. And I think it may well be possible that we can indeed our objective would be to negotiate UK-wide frameworks that provide a common framework for those things where there's a clear advantage in leaving it at the UK-wide level. The whole point of deep dives, these negotiations, is to try to identify where we can agree on those things that are best dealt with in a UK-wide framework, and where are those things that should simply be left to the judgment of individual administrations.
Could you describe the process that you envisage for agreeing the frameworks within that 5-year timescale that you mentioned?
It will involve, first of all, a lot of detailed groundwork between not just Lucy's team, but the teams of officials in the relevant government departments. So let us take food labelling. There will be the people from the Constitutional Affairs team. The territorial offices will have to be looped into that in some way. But the key roles are going to be played by officials from the devolved administrations and officials from the relevant ministry, in this case DEFRA. And they will have to go through what the current legal arrangements are, what the interests are of the different administrations, and try to find an agreed way forward. That obviously then comes up to political level for discussion, decision at the end of the day. Lucy, I mean,
yes,
to add something to that.
In a sense, there are sort of 2 stages on each of these frameworks, depending on the use of Clause 15. So, in the example that the Minister gives, DEFRA might work with the devolved administrations first on, well, in that particular area, which regulations do we want to freeze so that we've got a temporary arrangement that sticks to the current EU rules across the UK, so that we've got one regulatory regime in place on a 5-year basis. And then it gives us time to work subsequently with the devolved administrations to say, well, what should the future longer-term regime here look like? How do we co-design that? How do we come to consensus on it? And how do we then legislate for that? And we would envisage potentially that meaning further primary legislation, as I described, which would be subject to the Sewell Convention. So a lot of detailed official work needs to happen, but there are 2 potential stages in establishing the framework.
And what if there's no agreement? What if, for the sake of argument, one of the devolved administrations doesn't agree, but the other 2 do? Is this going to be a question of Whitehall being the final arbiter, or is there going to be a vote amongst the administrations? What has been thought of for that situation?
Well, our intention will be to work to get agreement, because that is in everybody's interest. And ultimately, the ultimate sovereignty of the Westminster Parliament is a constitutional fact.
Well, indeed, but from practical purposes, would it be simply a question of Westminster imposing, or would it seek the support of other devolved administrations to try and get a if not a precise consensus, at least a broad consensus? I mean, forgive me, before you interrupt, I have it very much in mind, of course, that the Scottish Government has been unwilling to play ball so far as the Withdrawal Bill is concerned, and if they maintained a similar stance, you would be having 5 years of extremely difficult negotiations.
Well, I am proceeding on the basis that we can and should continue with the sort of practical and professional negotiations that have characterised the framework discussions so far. And I think that the interests of Scottish business and Scottish consumers, as business and consumers everywhere else in the United Kingdom, are what ultimately matters here. And certainly the conversations I've had in Wales, Scotland and Northern Ireland have left me in no doubt that businesses in all parts of the kingdom want to see the continuation of UK frameworks. The most telling example was a public statement from the Scottish Retail Consortium, Scottish Food and Drink Federation and Scottish Bakers about a month ago, which said very plainly that they wanted to see continued UK-wide food standards and food labelling regulations, and they regarded those as essential to their business interest and to the interests of their customers.
Does the government have a vision for devolution post-Brexit? And if so, what is it?
I think that first of all, I would argue that well before the referendum, the government has established a track record of additional devolution where there is both a clear demand for it and a persuasive case.
Demand from whom?
From the devolved areas themselves. So
do you mean the devolved administrations or the people of the devolved areas?
Devolved. You look at both. You obviously take serious account of the views of the administration. They are elected after all. You take account of the views of the legislature, and you try to gauge, as we all do on many different issues, they
don't necessarily always coincide.
The general public. But what we have is a track record of having devolved further powers to both Wales and Scotland. In the case of Scotland, very significant powers over taxation and over some elements of welfare. I think we don't have a sort of particular end state in mind, but I think any case for further devolution is something that would need to be justified in terms of good public policy and in terms of having demonstrable democratic support.
And benefit.
And benefit, yes. And benefit in terms sometimes of accountability as well as in terms of what you think the benefits of allowed divergence might be.
Okay. Thank you very much.
Just picking up one or 2 points. The disagreement with the Scottish Parliament on the EU withdrawal bill creates is it just an event, or does it create a situation which is ongoing? And what are the consequences of that?
Well, I think it's too early to make a firm assessment. My hope is that we can continue with the professional business-like approach that we've had up to now, because the practical issues about food labelling, about fisheries, about chemicals regulations and so on are not going to go away, and they need to be addressed in a particular timescale because that is dictated by the EU treaties and by the provisional text of the
long-term consequences?
Withdrawal agreement. Well, I hope it is certainly, this is what is true, is that this is the first time in which we will have legislated at Westminster despite a legislative consent motion having been refused. It is also, I believe, the first time in which the Scottish Parliament has overridden the considered view of its presiding officer that the continuity bill, in this case the repeated legislation, was out with the competence of the Scottish Parliament. I mean, in the immediate term, there will be a hearing at the High Court, at the Supreme Court next month, to determine the outcome of the case, which will basically ask the court to rule on how we deal with the fact that we will have the withdrawal bill and the Scottish Government, Scottish Parliament's continuity bill, which each legislate for the same areas of competence, so that contradict each other in a number of respects. Now that is simply going through the normal process in which we would resolve a serious constitutional disagreement. And there have been, not with Scotland but with Wales, there have been references to the Supreme Court in the past in comparable cases. So my hope is that the interests of people and business in Scotland, in Wales, in Northern Ireland, in England, will mean that all the governments and legislators involved will see the importance of working together and getting on with the job on behalf of the people that we we represent. At the end of the day, people in Scotland and in Wales at the moment have 2 elected governments, and they have 2 legislatures, and there are members from Scotland, Wales, and Northern Ireland who sit in the United Kingdom legislature.
But, it does beg the question what the purpose of enshrining a convention in statute is, if it in the end becomes a cause for fissure and bitter division rather than something everybody agrees about.
Well, I think what you have by referring to it in statute is that it places beyond any doubt at all an obligation on the United Kingdom government of the day to seek the consent of the devolved legislatures for something that interacts with their competence. But you do have to read that clause of the respective devolution acts alongside the sentences that also make it clear that nothing in that legislation detracts from the ultimate sovereignty of Westminster to legislate for the United Kingdom.
But what is the point of having a convention which creates an expectation in different parts of the United Kingdom which the government of the United Kingdom has got no intention of honouring?
The government of the United Kingdom has demonstrably honoured it. Yes. I think what we have, the reality is that the current Scottish Government has a declared objective of seeking to separate Scotland from the United Kingdom, to establish Scotland as a completely independent state. Obviously, the Scottish National Party is perfectly entitled, the Constitutional Nationalist Party, to campaign for that and to seek votes for that. But that is, that is in a very different constitutional objective than from that of the United Kingdom government or unionist governments in other parts of the UK.
So what alternative mechanism or statement could provide reassurance?
But I think that we have in the intergovernmental agreement provided ample reassurance that we will continue in all respects to work in accordance with the Sewell Conventions in every relevant piece of legislation that we bring forward. And we've said that despite the fact that the Scottish Government and Parliament have not agreed to a legislative consent motion, have not withdrawn their continuity bill, that we will actually, in our dealings with Scotland, as much as in our dealings with Wales, apply the political commitments that we've entered into under the intergovernmental agreement.
Yes, Mr. Jones.
Yes, I share the Chairman's concern about incorporating the Sewell Convention into statute, because it seems to me that doing so actually added nothing to its strength. It was, if you like, purely symbolic and nothing more. It seems to me that the most important word in that particular section is the word normally. I think it's normally or usually. I think it's normally. Do you think that it might be an idea for the government and the devolved administrations to seek to arrive at an agreement as to what the word normally means in the context of devolution? Because it's extraordinarily vague.
While I'm always willing to look seriously with an open mind at any constructive suggestion coming from the devolved governments and legislatures, I suspect that a definition of normally is always going to be a matter of judgment.
What was a pity it was put in the Act then, really, isn't it?
Well, it's interesting. I think the decision at the time was that enshrined a principle that, other than in the most unusual circumstances, the UK government would always not just seek consent, but would not act without consent. Say we would not normally act without the legislative consent motion being agreed.
Thank you.
We've covered some of these bits already, but we just want to make sure that we've collected all the evidence we want by asking these questions. Mr. Hopkins.
Yes, thank you, Chair. when will the white paper on common frameworks be published?
What's our latest one? I don't think where we are on this one.
So
white paper on this, have we?
I don't. We haven't got a plan for a white paper on common frameworks per se. We've published various sort of items on common frameworks to show our progress, like the principles through EN and the list. And then, for consultation purposes, we'd expect white papers, etc., on those frameworks to be published by the relevant departments when they bring forward a proposal that they want to sort of test. So we're expecting white papers and consultation to be done sort of in the normal way through Whitehall departments who are responsible for those policy areas.
The government said we will publish a white paper on our ambitions for the future partnership with the European Union. There will be both white papers and consultations on different elements of that, and on the, more specifically, on the legal regulatory regimes that we will need post our exit from the EU, and those will have to go for consultation in the usual way with the development. Those will be led by individual government departments.
I'm sure as a backbencher I'm not alone in looking forward to more detail from the government. But could you outline in a little more detail the process and procedures for how the common frameworks will operate?
Well, that's something. I mean, Lucy can fill in the detail, but I mean that's something that will arise issue by issue from the deep dives and the official level conversations. I mean, up till now, while the frameworks have been going on at political level, being concentrated very much on the wording of Clause 11 now, Clause 15 of the bill. That's where our focus has been. I very much want to get on to where we go from here. The framework might take the form of a bill, of primary legislation here. It might be something that you could deal with in part at least by secondary legislation, depending on what powers exist under statute. It'll be horses for courses.
And the question that you asked, which is a very good one about how the frameworks ultimately operate, is certainly something that's being explored in the deep dives, but we're also doing sort of work on cross-cutting themes with the devolved administrations, and governance of frameworks is one of those themes. So we recognise that question. It's a work in progress at the moment, so we don't have sort of answers to that yet.
Well, we look forward to a more British approach to these things rather than the opaque EU approach, I have to say.
I mean, I was expecting an answer more on the lines of this is how we will meet and discuss, and this is how we will agree, and this is the time frame that we would expect a framework to be agreed, or at least there would be a timetable set out for each of the frameworks about how they're going, setting out how they proceed in the discussions and what the timetable is for agreement, and that resorting straight to a piece of legislation just echoes what led to the confrontation over the EU withdrawal bill.
No, don't misunderstand me, Chairman, please. It's not. Mr. Hopkins said that ultimately where would this lead, and it might be that it would be a piece of primary legislation. It might be secondary legislation. What we have tried to do already in categorising the competences returning from Brussels is to distinguish those that need no further action from those where we need a UK-wide framework but it doesn't need legislation, to the 24 areas where we think a legislative framework is likely to be needed, but in some at least of those it's likely to be only parts of those competences that will need the legislative framework. So part of the work that the deep dives and discussions are undertaking is to really go with a fine-tooth comb through what each of these competences means in practice and challenge ourselves to see to ask whether we really do need legislation for every single aspect of this, or whether there's some things we can simply say, actually, no, that we can simply push forward with straight away. That can go down to devolved level, or we just need a memorandum of understanding rather than a piece of legislation.
Following the chair, right. But it seems to me that it's work in progress and you're still thinking about this. but we would like to see the government's proposals in the end before we have proper legislation. Is that fair?
Well, you will see, but I think the precise arrangements are likely to differ from one competence to another, from one department to another. And I do want to emphasise that this is something where it is the lead departments, the policy areas, that are playing an absolutely key role here. You're getting into the stage where you have to have discussions between technical experts when you're dealing with things like food standards or agricultural regulations.
Thank you.
I would like to see the government setting out a set of principles by which would create a much more certain framework about when and how things are going to be discussed. And why shouldn't there be a white paper on how frameworks are going to develop?
But I think it is for individual departments increasingly to take the lead on this now. I'm sort of slightly reluctant to commit to a white paper on frameworks generically, because I just question whether that would actually give the committee and Parliament the kind of detail that people would really want to have, which would actually be about the content of the frameworks rather than the process by which they evolved.
But I mean, it's about having a white paper on process rather than policy or implementation. It's about having some clarity. But I mean, when you go to the European Union, you always know what you're going to discuss. You always know the procedure you're going to be in. You always know the other people that are going to be around the table of the Council of Ministers. Where is the same stability that we're offering the devolved administrations and the devolved parliaments? In this process, it just doesn't exist.
So I think we've got more laid out than that. So I think we've done a lot of work to narrow this down to the 24 areas which we've published.
Okay, where is it laid out?
We've now got the deep dives which I've promised to write to you to set out. We've got the procedure through clause 15, which produces quite an onerous task on us to set out then why we're freezing those areas and how we're going to go about that. And then we've got the sort of sunset clause in place, by which time we have to have come forward with a more permanent solution. And what we're doing with the devolved administrations now in our phase 2 of deep dives is trying to work out where we are in relation to those clause 15 freezes and what the next steps are on the more permanent framework. So I think we are in a process on that, and we could perhaps set that out for you in a bit more detail after this session so that you can see it mapped out.
I'm grateful for that, but I follow these things quite closely, as do other members of this committee, and I would suggest that this is a bit of a fog. I don't know how many other colleagues in the House of Commons have the least idea what we're discussing now, and yet it's very important. And I don't imagine that the devolved parliaments and the devolved administrations are enjoying much more clarity, except perhaps the officials who are actually speaking to and the officials that are actually engaged in discussions. But where is the openness and transparency in this? I don't see much of it.
I think there has to be a safe space for discussion and for disagreement between both officials and ministers from different administrations. I mean, certainly that's what I found at the JMC meetings is that actually it was important for us to be able to have arguments behind closed doors and to test out whether particular proposals would work or not.
This, having some laid down procedure and process and institutional frameworks does not preclude safe space behind the scenes to have those sort of discussions. Mr. Fysh?
Yes, really an expansion of that point. I think it would be very useful to see some of the timelines involved in some of these particular areas that you conceive of, because particularly with areas that are going to be of interest within a trade negotiation, clearly if we want to expedite those sorts of processes, then we need to understand what the timelines are and sensitivities are around agreeing some of these frameworks to be able to get started in any meaningful way on such negotiations. So that would be my request.
So, I mean, of course, one of the limiting factors is going to be that until we have greater clarity about the nature of the future relationship between this country and the EU and the consequences that that may or may not have for the framing of particular regulations, then it's difficult to be precise about the timeframes. And it will also be affected by judgments that the government has to make about handling a legislative programme overall and what can be accommodated within a particular bill.
As we said, we've had a lot of evidence about how unsatisfactory the JMC process is. I mean, what has been your direct experience of JMC meetings? How successful have they been?
I think they have, in my experience, in the last sort of 8 years I've been attending them and chairing a fair number of them. I think they are useful. I think that they don't work if they are seen as the only mechanism for consultation and discussion between UK and devolved governments. I think the JMCEs, not just as JMCE meetings, but JMCE under any format works best when it is underpinned both by regular sort of professional contacts between teams of officials, sort of shadowing, if you like, or feeding into the work that ministers consider, but also simply by what I tried to describe earlier as a culture of consultation and working together across the United Kingdom. I do think it's important for UK ministers not to wait till a JMCE meeting if there's something in their department which matters to one or other of the devolved administrations or legislatures. That you should instruct your officials to make contact, or if necessary, you pick up the phone to the minister in the devolved administration and talk to him or her about what needs to be done. And it's a mistake, I think, to look entirely to formal JMCEs as the way forward.
The Welsh Government published proposals for reforming intergovernmental relations last summer. What did you make of those proposals?
Well, we just agreed collectively at the JMCP meeting that we will have a formal review of intergovernmental relationships. That was something the Prime Minister and the two First Ministers agreed together that we would set in hand now, and that work has just started. There was quite a lot of work that was done over the previous 2 years to try to revise the Memorandum of Understanding that underpins these things. At the end of the day, that fell foul of one of the major parties in Northern Ireland, and Sinn Féin basically decided that they did not want to.
So this isn't just Welsh work; it's parallel for the.
What we now have in train is work across all jurisdictions. So it's the three of us, and I hope Northern Ireland will join us at some stage, who are working together on this review.
Well, perhaps in Lucy Smith's letter, this can be something of a formal statement of where you've got to and the direction that you're going in. And we could use that as part of our evidence base, but we would need it rather quickly. And we will then comment on it. Yeah. That would be very useful.
I think we'd find the committee's views on that helpful.
Well, it's not just our committee. It's the committees from the House of Lords, the Scottish Affairs Committee, the Welsh Affairs Committee, and committees in the devolved parliaments. They've all made this plea. Very similar to our own. And there is that parallel lack of, feeling of a lack of interparliamentary arrangements. We've got a meeting of the Interparliamentary Forum tomorrow, which is an informal mechanism, but I appreciate you said that was a matter for parliaments and not for the government. What proposals would you have for more formally notifying Parliament, the United Kingdom government, more formally notifying Parliament what JMC meetings are coming up, what discussions are going on? Because looking at the Scottish Parliament and the relationship between the Scottish Government and the Scottish Parliament, the Finance and Constitution Committee receives regular notices of what is going on, so that there can be scrutiny in advance of meetings that you're having.
I think the problem with doing this in advance is twofold. First of all, sometimes there is a need to have a discussion about matters that are controversial between different governments, and I'm back to my case for the safe space, but also the content of the agenda will change sometimes at very short notice. And that's not simply a matter of me or another UK minister deciding that we want something on the agenda. We may get a very late request from a Scottish or Welsh government to say we would like something on the agenda for this. But we do routinely publish the agreed communiques at the end of those JMC meetings. That. I mean, I can, if those are not formally shared with the committee, I'm sort of perfectly no problem at all with making sure that those get sent to you as a matter of course.
I mean, it can't. I think the last thing anybody wants to do is to sort of put everything in a straitjacket. So 3 weeks in advance of a JMC meeting, that's it, you can't change the agenda. I don't think anyone's suggesting that. But 3 weeks ahead of your proposed JMC meeting, what is it you're thinking of discussing? And where should it be discussed? It's like having European standing committees in advance of Council of Ministers meetings that are going to decide things, which are joint frameworks in the European Union. Where is the equivalent? Albeit, nobody's really happy with the quality of scrutiny that national parliaments can give what the European Union does. But where is the equivalent? Even to just make people aware of what's going on and give people an opportunity to discuss things. It just doesn't seem to exist.
Let me take that one away, Chairman, and reflect on that, because I think I understand the analogy you're making with the EU.
And once we're out of the EU, we will have some spare committees. We had very strong evidence in our earlier inquiries about how the devolution settlement was all about law and very little about process and relationships. And we've reaped the whirlwind from that in this process of exiting the EU. Now is the time to put in the missing component, and that was what we very strongly recommended before. And it still seems this message hasn't quite got through.
Well, I think I have argued already. I think that actually that though a lot of work has gone into both process and relationships, and it is a matter of sadness that the Scottish Government was not willing to agree to the compromise that the Welsh Government
no, but that's
was
not the issue.
Accept on this.
That's not the issue. Is it a bandwidth problem that the United Kingdom government's got? I think we would understand that. That there just isn't the capacity to do things in a more deliberate way that would allow for more open scrutiny. Is that the problem?
No, I think over the differences in terms of open scrutiny between the analogy you make with European institutions. Of course, the Council of Ministers is a legislature under the European treaties, and therefore it is considering documents that have either advisory or legislative status, and it's therefore perfectly proper that those are reported formally to the relevant scrutiny committees in Parliament, and that Parliament is informed what is coming up on a forthcoming Council of Ministers agenda. But what we're looking at in terms of the JMCs is something that is more akin to a cabinet committee, and I'm certainly willing to take away and consider whether we can helpfully try to provide more information to you about what is coming up
and
at JMCs.
And to the devolved parliaments, because, of course, a lot of the discussion about frameworks will result in United Kingdom regulation or even United Kingdom Acts of Parliament. These need to be, while these are being just stated, there needs to be proper discussion about them.
I've never noticed an absence of discussion. It sometimes takes place in the committees or debates referring to a particular subject, agriculture or fish or whatever, rather than at some sort of constitutional committee level.
The English dimension, Mr. Hopkins.
Yes, thank you, Chair. The government, the British government, UK government, has a dual role as the government of the whole of the UK and the government of England. So how effectively does it represent and advocate for the different interests within England compared with the devolved governments in Scotland, Wales and Northern Ireland?
Well, I think that the so-called eval rules have provided a useful additional check in terms of making sure that where a subject has been devolved to Scotland or Wales, that and the legislation here is England only in its effect, that there is a right for English MPs to have their voice heard and to give agreement to this, and both those tests have to be met. That it must be an England only piece of legislation, and it must be something which is devolved already to Scotland, and therefore a matter which, in respect to Scotland, members of Parliament here have no say at all.
It's very interesting you defaulted to talking about the legislative process when this question was actually about the process of government, not.
Well, in terms of government, I think we do have sort of involvement with. Can I just check this topic whether this is this question more about how English interests are taken into account within the JMC process, or is it more generally about EU exit and how English interests are taken into account there?
Well, I think it's both, but we have not had the kind of regional representation, for example, that we've had. I don't want to make a particular point, but the RDAs and the machinery of in the regions, was something of a voice. We've now got some big places like the big urban conurbations and we've had Andy Street and Andy Burnham speaking to us very, very effectively in recent times. So that they are starting to, but there seems nervousness always at the centre of giving too much, per se, to these kind of regional interests and whatever.
Well, just on the point about the JMC structure was set up for a very clearly defined purpose, which is to provide a mechanism for formal engagement at ministerial level between the government of the United Kingdom and the government of the three devolved areas. Now, when it comes to how English interests are taken into account, actually, if you look at what happens, we've had officials from HCLG and from the Department for Exiting the EU have worked with the Local Government Association. There have been EU exit regional sounding boards in Cornwall, Staffordshire, Newcastle and Tees Valley. Those two departments have also talked to a number of individual local authorities and representative institutions to try to understand the impacts of EU exit, and they've attended events organised by local government interests in England, in Newcastle and in Buckinghamshire. The Secretary of State for Housing, Communities and Local Government has hosted EU exit roundtables in local areas, including Cornwall and Great Yarmouth, to try and talk to them directly. Ministers from DEXU and other departments have gone to regional sounding boards. I think that a lot of that activity has taken place, and certainly when elected mayors or other elected local and regional leaders in England have had discussions with ministers. They have the implications of EU exit on their agendas. I mean, I think that is just a matter of routines. I don't think that they have lacked opportunity to sort of put their point of view to government.
Yeah. Can I move on? I mentioned Andy Street and Andy Burnham as well as the LGA. And the LGA told the committee that voices of English regions outside London have not been heard as effectively those in Scotland and Wales. Post-EU, how does the government propose to include English regional voices in intergovernmental decision-making, including within common framework bodies?
Well, I'll let Lucy speak about frameworks, but I think that the key thing is to make sure it is that the department concerned has the responsibility for ensuring that the interests of all parts of the United Kingdom are taken into account. Now, when we are dealing with Scotland and Wales and Northern Ireland, there are properly constituted, and in the first two cases, the most elected authorities with whom they can and should be dealing. And when it comes to England, the interests of different parts of England may vary. So, for example, in looking at what we do about the future of agricultural policy, it is quite conceivable that in some respects the interests of upland areas, Lake District, parts of the southwest in England, may align more closely with some of the interests expressed in Scotland and Wales than with those interested, say, East Anglia. And it is the responsibility of the Secretary of State and his or her ministerial team to make sure that English interests in the round are properly factored into their consideration of what the overall balance of the UK approach ought to be. I mean, it's exactly the same as currently applies when any department is devising and then framing its approach to a particular piece of EU legislation. Lucy, you said about frameworks.
Yes, of course. I mean, and I'm just following on from what the Minister was saying. Underneath all of these frameworks, there's a big policy question about what we should do in respect of, animal health or, whatever the other frameworks are. And those policy questions are led on by the lead UK government department, which has all of the mechanisms of its usual policy-making process in place to consult the various interests and stakeholders, both in England and across the UK. I think we do recognise a need to have stakeholders engaged on the common frameworks question itself, and indeed ministers have asked us to bring forward proposals as to how to do that over the summer. So that's something that we'll be looking at jointly with our devolved administration colleagues to make sure that we've got something that can be engaged with by Scottish, Welsh, English and other interests right across the UK.
With more time, I'd like to, I'm sure others would too, pursue these matters at greater length, but unfortunately there is a restriction there, and I have struck very definite views myself. But a key area for further devolution in England highlighted in our evidence surrounded skills, with a capital S we say. Do you think there should be an intergovernmental committee on the area of skill on which representatives of English regions are members?
It's not a question that I have personally considered, and I think, in fairness, that would be a matter primarily for the Secretary of State for Education, the Secretary of State for Bays to decide whether and how to take forward.
Just in conclusion, if I may, Chair, the Minister, you said earlier on, talk about the government deciding effectively what the interests in the regions. It's the voices of those who actually live and work and have their interests in the regions. That's the voice we perhaps is not as strong. It's all very well having departments deciding these things, but the voices of the regions.
But I talked to Greg Clark, James Brokerage about their diaries. They do spend a lot of time talking to mayors, to other elected leaders in England. So actually, I know that those colleagues do take account of the views that have been expressed to them. And if you look again at what has been going on, I mean, look at London, for example. I mean, when I was at Justice, I went to see Siddiq Khan at his request, and we discussed the possibility of some agreement between the national government and the mayoral administration on criminal justice in London. And David Gauke, since he's took over from me, has concluded a memorandum of understanding with the Mayor of London, so that he's getting greater support and some greater sort of freedom to influence the provision of centrally provided criminal justice services in London. And as far as London's concerned, if there are ideas that the mayor wants to pursue, for example, there's a real, I think it's a struggle for them to provide sufficient housing supply in London. Then again, I'm sure that the Secretary of State would be open to a conversation about how we can work in partnership to deliver that. So I think those opportunities are there.
Thank you.
Mr. Fysh.
So Andy Burnham and Andy Street, when they came before the committee, gave evidence about what they alleged was the over-centralisation of the UK and its governance in England. I just wondered if you could outline what your understanding of the government's current proposals for reform for the governance of England and the devolution of power and authority away from Westminster into the regions of England are.
Well, if you look at what's actually happened, first of all, we've had additional powers for the Mayor of London. We've got new mayoralties in West of England, Tees Valley, Sheffield, West Midlands, Greater Manchester, Liverpool. There have been other Cambridgeshire. There have been other mayoral projects that have foundered because some of the local authorities concerned have made it very clear that they did not want to take part. So my view is that incrementalism is the right way to go, and to learn from the experience from the successes and the failures of those early experiments in greater devolution in England. I think one of the biggest challenges is to work out what devolution means in an area where you cannot think of it as a city or a city region. And I think that lies behind the sympathy the government has expressed towards more unitary local authorities in Wiltshire, in Cornwall, most recently in Dorset. So there are ways of trying to devolve more power in rural and semi-rural areas, but I think the cities almost present themselves as potential candidates if there's sufficient evidence of local support for a mayoralty, but the real challenge is, what does devolution mean outside the cities?
And much of it obviously comes down to money. One of the things that we heard was that some of these devolved areas would like to see perhaps more of a commitment to the promise of honouring the devolution of the European structural funds once we, in theory, have control of those again. And the concern was expressed about whether the government, by saying that they wanted to check there was good value for money in doing so, in line with domestic strategic priorities, might sort of get in the way of some of those devolution principles. So I was just wondering, are you planning to devolve not just in the policy areas, but the means of implementing these things, and in particular the monetary means?
The money that is now spent on regional development by the EFU, we're intending to put into a UK shared prosperity fund, and there are discussions ongoing between ministers about precisely how that should operate when it comes into being. I mean, clearly there is a responsibility to ensure that money is well spent, whoever it is that takes the spending decisions. There is merit in looking at the case for devolution of funds, because that enables people who are on the ground understanding particular local challenges to take spending decisions. Against that, if we have, as we do, an industrial strategy that applies nationwide, that is designed to try to help in particular those areas that have been in danger of getting left behind economic growth elsewhere in the country, well then, as a matter of national policy, we need to take some decisions about how we deliver on our promise to give priority to those left behind areas. So these are discussions that are ongoing.
Thank you. Mr. Jones?
Yes, we've had several pieces of evidence suggesting that there's a tendency for Whitehall to hoard power rather than to devolve it. Would you say that that was a fair assessment?
I think it's an unbalanced assessment. I think it's probably, if you probably look at, I doubt that there's that many examples in history of systems of government that have not wanted to accrue power to themselves at whatever level those governments operate. But actually, you look at the track record. Departments right across Whitehall are working with the Scottish Government to implement the Scotland Act 2016, which was the biggest transfer of power to devolved level since the 1998 legislation. Implementation of the Wales Act 2017 is underway. The new reserve powers model came into force on the 1st of April this year, along with many of the actual new powers being devolved, and that means there's a far clearer boundary now between those matters that are a UK responsibility and those that are Welsh Government and Assembly responsibility. And as I said earlier, the repatriation of powers from the European Union is going to lead to a very significant and immediate addition to the powers exercised at devolved level in both Scotland and Wales. We're looking at something like 80 powers that are going to go to devolved level.
We've also had evidence that although there's clearly been a lot of constitutional change in the UK since 1997, there's been no adaptation of the architecture of government in Whitehall to accommodate and reflect these changes. Would you accept that criticism?
I'm willing to look with an open mind at suggestions about how things can be further improved, but I would point to the creation of the UK Governance Group in 2015 that leads cross-government work in the UK on constitutional and devolution issues. That supports me and the Minister for the Constitution, the territorial officers and the Advocate General for Scotland alike. And its purpose is to try to ensure that strengthening the Union is a shared responsibility across all UK departments. And I'm sure that there are ways in which we can continue to strengthen that habit of working together and of being alive to devolved issues. But I think there have been some quite significant changes.
We are repatriating all the powers that resided at Brussels very shortly.
Mm-hmm.
Do you think that there is any merit, for example, in creating a Whitehall department for the Union that might actually fulfil or exert the functions that were previously exerted in Brussels?
My initial starting point would be scepticism about that, because I think that it's quite hard to see how that model sits alongside the separate territorial departments, and I think that people in Scotland, Wales and Northern Ireland prefer to have a designated voice for their interests at the cabinet table and within government.
Has any research been done on that?
Not to my knowledge. I think, and I would argue too, Ms Jones, that the responsibility the Cabinet Office has for constitutional affairs overall and for the devolution settlement overall actually delivers most of what a department for the Union would achieve. And such a department, ought not, in my view, to be looking at only at those things that are returning from the European Union. That there are many things that about how we operate as a United Kingdom at the moment that already require cooperation and discussion between the UK and devolved governments, whether or not they involve European Union competences.
Your department clearly is going to have more pressure, I would have thought. Have you thought about redesigning its structures?
I think every department in government, frankly, at the moment is under pressure, not just the Cabinet Office. So
no, I'm thinking about in the medium to long term.
In the medium to long term, it's not something to which I've turned immediate attention. I think that at the moment I am satisfied with that the structure enables me to have access to the advice that I need on constitutional matters. I think that the challenge is ensuring that departments right across Whitehall are giving sufficient attention at all times to the specifics of devolved interests.
I mean, what clearly we need is effective interconnected government across the UK. And that is clearly going to be a further challenge once we have repatriated powers from the EU. Functions that were previously delivered by the European Union will have to be delivered in whatever way is agreed with the devolved administrations. I mean, do you not think that given the repatriation of those powers, given the additional functions that will be brought back on shore, it's necessary to change the architecture of government, perhaps in concert with the devolved administrations, to provide the sort of effective interconnected government that I mentioned?
I know. I think the model that first of all, I would say, let's not forget that most of those repatriated powers are going straight to devolved level, where they involve devolved competence in any case. We're back to the list of 24, where we think that there is a need for some kind of UK-wide legislative framework in whole or in part.
Which clearly are the most important competencies.
And those are, well, I mean, that is, there are some, I think, some very important competencies, for example, on environment, that
yes, but
do not...
forgive me, when I say important, I mean to the extent that these affect the UK as a whole and the relationship.
Yes, I mean, I won't quibble with that. But I think that my preferred model would not be to have a shake-up at the centre. It is more about ensuring that both the culture and the organisational structure of the relevant lead departments around Whitehall are taking full account of the fact that we're no longer dealing at EU level, but we are dealing with the different devolved administrations. Now, of course, what is also true is that those departments, and probably DEFRA and BEIS are the most obvious examples, at the moment devote a considerable amount of capacity to their EU business. And that, of course, does already require them to consult with the devolved administrations. If you go to a Fisheries Council meeting, you will find that there are ministers and officials from all of the devolved administrations in the delegation room with the UK government's team there. So this way of working is already there in Whitehall. I would agree with Mr. Jones, that we need to make sure that we are strengthening that and developing it further, so that we are able to have the sort of cooperative relationship that he rightly argues for in the new context.
Agriculture is a very good example, because it's the most obvious area that is going to be affected by our departure from the European Union. DEFRA's function, I would suggest, is going to change very extensively. At the moment, it exists as a department that simply processes regulations and directives that emanate from Europe. So it's actually going to have a policy-making function, which I would guess is going to be a function that affects the whole of the UK. Has any thought been given, for example, to maybe embedding officials from the devolved administrations in DEFRA to work with DEFRA in order to develop joined-up policy?
Well, that is a matter for the Secretary of State for DEFRA to decide. I mean, because of the way in which the acts are...
Forgive me interrupting, but is it just up to the Secretary of State for DEFRA, or is it not a question of development of policy at the centre?
It is primarily a matter for the Secretary of State for DEFRA, because what we're looking at is devising a new agricultural policy for England. There will be aspects of agricultural policy which, given what the description of competencies and allocation competencies in the Devolution Acts say, will be for the governments of Scotland and Wales, respectively, to determine. The thing that has to be negotiated is the extent to which some areas of agricultural policy, perhaps not all, need to be covered by a UK-wide legislative framework.
Yes.
And what is said in that framework, what provision is made for there to be a measure of divergence, and what is the right balance in that framework between divergence and conformity. And when the Secretary of State is preparing new policy, but has not yet, we have not yet come to an agreed government position on this. I think it's wrong of me to speculate too much about how that would actually operate. But he's very, very well aware of the importance of taking seriously the interests of the devolved areas of the country.
Briefly on Northern Ireland.
Yes, very briefly, we've had various discussions in the media, etc., about Northern Ireland, but there's been less focus, perhaps, on some of the citizenship and identity issues that arise because of the ideas around devolution and the border in particular. I was just wondering if you might say a little bit about how the government proposes to deal with those issues, and in particular comment maybe on this issue that came up, for example, of Whitehall not realising that when recruiting for the UK border force, it wasn't going to be a good idea to say that British passport holders only need apply. I was wondering if you could say a little bit about how Whitehall's going to come to grips with some of these nuances and differences of how to work with the devolution settlement in Northern Ireland.
Well, I think that last point was something I think the Home Office, as soon as it was drawn to their attention, took action to correct. In terms of the negotiation, there have been some very positive steps. That we've got agreement on the continuation of the common travel area between the UK, Ireland, and the Crown dependencies. And there's been some very good progress in the last couple of weeks on the single electricity market, something that's very important to Northern Ireland. The priority remains for us to deliver on the joint report commitments that we entered into in December last year, and that means avoiding a hard border but maintaining the constitutional and economic integrity of the UK as part of that overall UK-EU partnership. When I've been out to Northern Ireland, what I pick up from business very plainly is that maintaining a no hard border between the two jurisdictions on the island is of enormous importance. This is something that matters to businesses both large and small, but equally the free passage across the Irish Sea, the fact there's no customs checks in the Irish Sea, is also of huge importance, both economically, because the trade north-south is dwarfed by the trade that both Northern Ireland and the Republic of Ireland have with the rest of the UK, but also it's politically important, and both the Belfast Agreement and the joint report of last December were very carefully, delicately balanced documents which seek to protect both north-south and east-west relations. If you look at the joint report, paragraph 50, which is the one often quoted, says there will be no border in the Irish Sea. But paragraph 42 says in terms that both sides, we and the EU, commit ourselves to upholding the totality of relationships embodied in the Belfast Good Friday Agreement. The totality of relationships is every bit as much north-south as it is east-west. All of those strands were very carefully knitted together.
So once we hopefully get a power-sharing executive back in place in Northern Ireland, how much power and authority will the Northern Ireland Assembly have to make its own decisions once the various other parties have made their
once I preface what I was going to say by saying it is very frustrating and unsatisfactory at the moment that there is no elected Executive Assembly in Northern Ireland with which we can deal, because while we keep the Northern Ireland Civil Service fully informed about our conversations about devolved matters, and the Northern Ireland Civil Service attends JMC meetings in an observer capacity, it's not the same thing as having ministers around the table. Secretary of State for Northern Ireland holds briefing meetings from time to time with the different political parties in Northern Ireland, but again, that's not the same as having a functioning executive and assembly. So the sooner devolution can be properly restored in Northern Ireland, the better. As soon as that happens, then we will see Northern Ireland ministers formally involved in JMC, and they will be able to give political direction to their officials, which means their officials in Northern Ireland Civil Service can play a more creative part than they're able to do at the moment, when they see their role as basically trying to maintain the position that the last lot of Northern Ireland ministers had managed to agree upon.
So how does that interact with this process of establishing the common frameworks that we talked about before? I mean, is the lack of a ministerial input from Northern Ireland holding up that process in any way?
So it's not holding up the official level work, which takes place with officials from the Northern Ireland Civil Service as well as from the Welsh Government and the Scottish Government. But as the Minister says, it means that when these come back to political level conversations, the Northern Ireland Civil Service is only there in an observer capacity, and they're not. You don't have politicians engaged in that debate.
So are we going to have to set those frameworks without political input from Northern Ireland? Itself.
I mean, I hope we don't, but we clearly will have to have that risk in mind. The part of the problem we have at the moment is that the Northern Ireland Civil Service does a professional job attending the meetings that we've described, but they will say that they don't have power to initiate, and you need elected ministers to give them direction under the terms of reference of the Northern Ireland Civil Service. And there's even a court case that is ongoing at the moment, where they'll be hearing in the Supreme Court, I think next month, which will where the Northern Ireland Civil Service is being challenged on the grounds that it is doing more than it is empowered to do in the absence of of an executive. Now, that's not in respect of anything to do with frameworks. It's a completely separate matter. But there is quite an important principle that's involved in that court case.
Okay. Thank you.
Well, you've exhausted us, Secretary of State Lucy Smith. Thank you very much indeed. You've contributed a great deal to our evidence, and we now look forward to drafting our report, which I hope you will find interesting and helpful.
Thank you very much.
Thank you very much indeed. Order, order.